Hi everybody, Dana Sparks, broker of Maximum One Greater Atlanta Realtors, and today's contract tip is all about contract terminations versus the disbursement of earnest money. So for whatever reason, there seems to be a lot of confusion in our marketplace regarding these issues. So let me start off by saying that these are two completely separate, yet related, but they are completely separate contractual issues. One issue is the termination of a contract. The other issue is the release of the earnest money that is on hold per that contract. So they are related, but they are separate. So first of all, for the actual forms themselves, for the GAR purchase and sale agreement, or for the GAR contract forms, I should say, the actual TNR that we refer to euphemistically, and the T stands for termination, and the R is for release of earnest money. That is on GAR form F522, and the name of the form is actually the unilateral notice to terminate purchase and sale agreement and proposed disbursement of earnest money. So in GAR, in the Georgia Association of Realtors forms, they handle these two different issues on one form. In the also, GAR has a form for a mutual termination and release of the earnest money, and that is GAR form F519, and it's called the Mutual Agreement to Terminate Purchase and Sale Agreement and Disperse Earnest Money Mutual Agreement. In the RE contract package, these two issues are handled on two separate forms. So in the RE contract package, there is form RE 263, which is the notice to withdraw or terminate, and then RE form 212, which is the agreement to disperse trust funds. So first of all, let me back up and say I have done several contract tip videos on terminations and releases, and I did one relatively recently on seller terminations, contractual terminations of a contract. Now, the other thing I want to say is a termination of a contract is done by notice, and all notices are unilateral. So you only need one party's signature to terminate a contract. And once a contract is terminated, it is dead. It is terminated. You cannot amend a terminated contract to bring it back to life. So as an agent, when you are interacting with your clients and customers, and one of the parties wants to terminate a contract, and then a day or two later, you want to revive that contract, you need to start all over with a brand new contract. Once it has been terminated by the parties, it is terminated. You need to start all over with a brand new contract. If you are representing a buyer and the parties terminate a contract, and then the buyer wants to revive that contract, or the buyer and the seller want to revive that contract, you may have some issues with the lender regarding a new purchase and sale agreement, and the buyer might have to wait 30 days or so, depending on the loan type, and so forth and so on. So before a party terminates a contract, there are a lot of discussions that need to occur between the parties, with the agents, with the lenders, title search, so forth and so on, especially with the lenders. So once a contract's terminated, it's terminated. And the issue is, and anybody can terminate a contract, buyer or seller. The issue is the other related but separate contractual issue, which is the disbursement of the earnest money. So who is entitled to the earnest money? The termination of a contract is unilateral, meaning you only need one party's signatures. However, in order for a holder to disperse the earnest money, the holder must have agreement. The holder must have a document signed by the parties that have an interest in those funds, which is the buyer and the seller, agreeing to the disbursement of the earnest money. Now, the buyer and the seller can agree to disperse those funds however they choose, all to one party, all to the other party, split it up, whatever. If the holder of the earnest money gets that in writing, then the holder disperses of the funds regardless of the circumstances surrounding the termination. If, however, the holder does not get a written agreement signed by the buyer and the seller agreeing on directing the holder how to disperse those funds, then there are a lot of issues or a lot of remedies allowed for the holder to figure out how to disperse those funds. The most common one is what we call the 10-day letter, and I've done videos on this, where the holder interprets the contract, makes a decision as to why did it fail to close or why did it terminate. The party that terminated, did they terminate by an unexpired agreed upon contractual contingency, or did the party that terminate by default? So those are issues for the interpretation of the contract. Now, one note on this before I go any further. If it is an all-cash contract and the closing attorney is holding the earnest money and the parties are binding on a GAR purchase and sale agreement, then regardless of the circumstances surrounding the termination or the failure to close, all-cash contract, closing attorney holding the earnest money, the closing attorney is not allowed to use this 10-day letter and interpret the contract. Closing attorney must interplead those funds into a court and let a judge decide. That does not come for free. There are costs associated with attorney's fees to file the motion to interplead the funds, court costs, filing fees, so forth and so on. And all of that money does come out of the earnest money. So just make a note, when the buyer and seller choose to have a closing attorney as the holder of the earnest money in a cash deal, if there's an issue and the closing attorney doesn't get agreement, it's going to have to be interpled if they're binding on a GAR contract. Okay, so now let's go back to this. Again, once it's terminated, it's done by notice, therefore it's unilateral. The questions come in regarding the disbursement of the earnest money. If the parties don't sign that agreement to disperse the earnest money, then contract interpretation occurs. So before we even get to there, if you are, let's say a buyer terminates a contract, and in the form, they terminate the contract, so it's dead, and in the proposed disbursement of the earnest money, the buyer states that the buyer will get the earnest money back. The seller, however, disagrees. The seller thinks that the buyer terminated outside of a contingency, and the seller thinks that the seller should get the earnest money as liquidated damages per default. And I'll get to that in a second. Well, if you're representing the seller and you receive a TNR and the proposed disbursement of the earnest money you don't agree with, you don't do another TNR. It's already terminated. All you do is you don't sign that proposed disbursement of the earnest money, and you let the holder know the earnest money is in dispute. But you don't execute a new TNR. That's ridiculous. It's already terminated. What is at odds is the handling of the earnest money, and there are other contractual as well as license law provisions for the holder to disperse those funds and a process to figure that out. But so you would just not have the seller sign that, or if it's the other way around, just don't have your party sign the agreement to disperse the trust funds. Let the holder know it's in dispute, and then the holder does their job as prescribed in the contract. And if the holder is a broker, by license law. If the holder is a closing attorney, unless they hold a real estate license, they are not held to license law. So the other thing why this is important is, let me point out to you, in the GAR purchase and sale agreement, as well as in the RE forms purchase and sale agreement, the default clause. So in paragraph, in the GAR purchase and sale agreement, which is F201, and the default clause is in paragraph B2, default. The remedy for the seller, the sole remedy for the seller, if a buyer defaults, is the earnest money as liquidated damages. If a buyer defaults on a purchase and sale agreement, so if the seller defaults on a contract, the remedies for the buyer is the buyer can terminate the contract, get their earnest money back, and go about finding another property, or they can seek specific performance, meaning they file a lawsuit against the, well, I don't know if it's a lawsuit. I guess it is a lawsuit. They file a suit with a court, and a judge decides if the seller must honor the contract or not. Now, it's not for free. The buyer still has to pay for it. But that's what specific performance is. Now, and that is in the GAR contract. It also says attorney's fees in any litigation or arbitration arising out of this agreement, including but not limited to breach of contract claims between buyer and seller and commission claims brought by broker. The non-prevailing party shall be liable to the prevailing party for its reasonable attorney's fees and expenses. Now, in the RE forms contract, it is under the standard terms, which is RE1. And again, it is in paragraph 10 under default. And same thing, if a buyer defaults, the seller's sole remedy, and this was changed in 2019 in the RE forms contract, is the earnest money as liquidated damages. And should the seller default, the buyer's remedy either is to get the earnest money back or to pursue a specific performance case against the seller. So that's why this is important. It's not just earnest money. And also under default, let me go back to that. The party that terminates a contract, if they terminate by default, the brokers may also pursue the defaulting party for commission. So it's not just earnest money. The defaulting party, if there is a termination by default, are also potentially liable for commission to both brokers, as well as attorney's fees if it does go to litigation and a party loses. So let me give you a couple of cases why I'm bringing this issue up as a video. We've had, for whatever reason, there have been a bunch of contracts that have terminated by a seller terminating the contract. And like I said, I did a previous video tip not that long ago on contractual reasons a seller can terminate. Once a seller has signed a purchase and sale agreement, there are very few contractual termination rights for a seller. Nevertheless, a seller can terminate a contract. The issue is, did they terminate by default, or did they terminate by an agreed upon contingency or an other lawful reason? So, for example, there's one where the seller terminated, the seller was a new construction builder, and the seller terminated the contract because the buyer had become very difficult to deal with. The buyer had become so difficult to deal with that the seller actually had given notice to the buyer that the buyer was no longer allowed on the property, and should the buyer show up on the property, that they would file a criminal trespass warrant against or order against the buyer. So at that point, the seller did terminate the contract. There was no contractual right for the seller to terminate. So the seller clearly terminated by default. Nevertheless, once it's done, it's done. Now, in that case, I believe the seller did agree to give the buyer back not only the earnest money, but all the quote-unquote non-refundable security or construction deposits. The seller, even the builder, gave the buyer back those funds as well. There was another one where seller, another new construction, terminated the contract. Did they terminate by an agreed upon contingency? No, the seller terminated by default, and the reason was the seller just decided to not build in that subdivision or in that area anymore. So in that situation, again, even though the seller terminated by default, in the agreement to disperse the trust funds, the seller was giving the earnest money back to the buyer. The buyer signed it. Even though it was a default, it was done. The issue is, well, let me give you another one. There was another one where another new construction issue, the seller terminated, and the reason was because the zoning of that area changed, and the seller was now prohibited by the zoning regulations and could not build. So that one terminated for other lawful reason, not a default. The buyer got the earnest money back and went and found another property. There was another one where a seller terminated. Buyer wrote an offer. Seller wrote what they thought was a counteroffer, and instead of writing it on a counteroffer form, the seller did the mark through initial date and time, sent it back to the buyer. However, through the electronic, they did it through one of the e-sign systems, and in that system, there was nothing was marked through, so they just sent it back. It got bound, and the parties are under contract. The seller then realized that they were under contract for a different price than what they thought they had made a counteroffer to. I don't know why the seller didn't use the counteroffer form, but nevertheless, so the seller terminated. Clearly, seller terminated by default. The issue is the agent, the buyer's agent, called me up and said the seller can't terminate. And I said, yes, they can. And the agent says, no, they can't. And I said, yes, they can. Once it's terminated, it's terminated. The issue is, was it a termination by a contingency or was it a termination by default? Clearly, it was a termination by default. And then what gets negotiated or decided by the holder is the disbursement of the earnest money based on the party that terminated by default. But the agent said, no, it's not a terminated contract because the seller can't terminate. Well, yes, it was a done deal. It was a dead contract once that seller signed and sent over that notice of termination. So just because a party terminates by default, meaning outside of a contingency time frame or for no contractual reason, it doesn't matter. Again, the consequence of that is the disbursement of the earnest money, which is a completely separate issue. But once it's a done deal, it's a done deal. There was another issue where, again, we had a seller terminated. And the issue was they had received the buyer, they were under contract, and the buyer was getting a VA loan. And the form of the earnest money was in a personal check rather than in certified funds. So the seller terminated. Well, that was the seller. There was no termination rights built in to the form of the funds. This goes back to another issue that I've talked about don't write any special stipulations because they typically don't have the time frames, notices, and consequences built in that you guys do. There was another one where, there was another one where the party terminated. It was under a financing contingency. The buyer terminated. The buyer sent over the loan denial letter, and the seller did not agree with the reasons of the loan denial letter. So in that situation, the seller did not sign the TNR, so the holder had to go through the 10-day letter interpretation process. And just because the seller doesn't like the reason, if the contractual obligations for termination and for contingencies were met, then the buyer had terminated by an agreed upon contingency. So my point is a couple things. Number one, termination is unilateral. It's done by notice, therefore it's unilateral. You only need one party's signature to terminate. Once it's terminated, it is terminated. It cannot be revived. A terminated contract may not be revived by amendment. You need a whole new contract. So if a buyer's getting an FHA or a VA or USDA loan, that could cause a whole set of issues for that buyer. They may not be able to write a new contract on that same property for a extended period of time. So be leery of that before terminating a contract. The second thing is a seller or a buyer, either party, may terminate a contract even by default. So even though there's no contractual provision for that termination, then if it is a default, then again, that has consequences on the earnest money, but not on the contract. Once it's terminated, it's terminated. The other thing to consider is if you have an attorney holding the earnest money and it's cash, then the interpretation process is not available to that attorney to decide the disbursement of those funds. And the other thing is if a party does terminate by default, if it does, not only is it the earnest money that can be dispersed as liquidated damages, but the brokers, the selling broker and the listing broker may pursue, if it is a termination by default, may pursue the defaulting party for commission. So just a couple of issues. Now, one more thing. Oh, and specific performance. So just one comment on specific performance. If there is a suit from a buyer against a seller for specific performance, if a seller does default or there is a perceived default, if a seller terminates a contract by default and a buyer is going to seek specific performance to get a judge to decide if the seller does have to actually go through with the contract, one of the things that may happen is the buyer would file, and there may be a different specific legal name for it, but the buyer would in essence file an injunction against the seller, preventing that seller from selling the property to another buyer until this specific performance lawsuit has been heard. So there are a lot of other issues. If the buyer and seller are involved in an issue especially where specific performance, where a buyer is going to seek specific performance against a seller, then definitely they would want to get legal advice. But nevertheless, the point of this contract tip was just to point out to you as an agent, there are a lot of issues to consider before a party actually terminates a contract. There's time frames, contingencies, forms of notice, and the consequences of a termination. And just because a party does not have a contractual contingency under which to terminate the contract and protect their interest or protect their earnest money, doesn't mean that it still cannot be a termination by default. Again, please check out some of the other videos in the playlist section under Earnest Money and check under videos. I have done several videos on terminating contracts. Thank you guys so much for watching. Comment below. What do you think? Thank you for watching. Dana Sparks, broker of Maximum One Greater Atlanta Realtors, satisfying your needs with service, innovation, and education.